Good afternoon. Happy Tuesday. This video came out the other day on the 25th, so yesterday. And Delete Laws, he is so proud of this monster motion. Now, I don't know who wrote it, don't really care. But like having sex on an elevator, it's wrong on so many levels. This is a motion to dismiss for lack is what normally they say, of jurisdiction. Now, typically, if a defendant is going to file a motion for lack of jurisdiction, they're going to identify what kind of jurisdiction the court is lacking. And there are three types of jurisdiction, at least that I'm aware of. But I'm only a first-year family law attorney, so take all this with a grain of salt. The first kind of jurisdiction, the easiest one to prove or disprove, especially in a criminal case, is personal jurisdiction. And personal jurisdiction is established if the cop pulls you over and hands you a citation, or if he arrests you and drags you in front of the judge. That establishes the personal jurisdiction of the court over you. That's pretty cut and dry. The second one is subject matter jurisdiction. This also, generally speaking, tends to be pretty cut and dry. For example, if DA wants to charge you with a federal felony in a state court, well, in that particular case, the state court lacks jurisdiction. Or conversely, if a assistant U.S. attorney tries to file a criminal case against you for a violation of a state law in federal court, that's also going to be the wrong subject matter jurisdiction. A federal court does not have subject matter jurisdiction over state criminal causes of action, and state courts don't have subject matter jurisdiction over federal criminal causes of action. And another big example of this was the McGirt decision, Supreme Court. If an Indian commits a crime on Indian lands, or if there's an Indian victim, I believe the tribes have jurisdiction, and the state may also have concurrent jurisdiction. But anyway, on Indian land, if an Indian commits a crime against another Indian, I'm positive that in that case, the Indian tribe would have jurisdiction over, and the state would not. If a non-Indian commits a crime on Indian lands against a non-Indian, then the state would still have jurisdiction over it. So that's subject matter jurisdiction, and I'm sorry to get off into the weeds on that. And then the third and final kind of jurisdiction is territorial jurisdiction. The state of California can only prosecute you for crimes committed in the state of California. Now, they might try to play games where they say, well, if you commit a fraud on a California citizen from another state, but you're committing, but you defraud them while they're in California, maybe California will try to exercise territorial jurisdiction over you, but who knows how much success they're going to have. But definitely, if you commit a crime within, for example, the state of Oklahoma, then the state of Oklahoma is going to have territorial jurisdiction over you. If you commit a crime within the bounds of the reservation, then the tribe that has that reservation is going to have territorial jurisdiction over you. Now, in this particular motion, whoever drafted this does not really lay out clearly what kind of jurisdiction that they're saying that the court lacks. Now, having read through it and parsed it together, I'm pretty sure they're saying that the court is not authorized to act, just period. There's no authority granted to this court to hear the case. I don't know exactly what that is. I think they're just saying the court's illegitimate. And then the other jurisdiction I believe that they're trying to argue is territorial jurisdiction. Now, they start off by going on to talking about the Kitoa, I hope I'm saying that correct, which is another tribe of Indians that shares the Cherokee Nation reservation. On the Cherokee Nation reservation, there are two tribes of Indians, two federally recognized tribes of Indians. There is the Cherokee Nation of Oklahoma, and there is the United Band of Kituah Indians, or the United Kituah Band of Indians and they're also Cherokee. Anyway, so we know that those two exist, and we know that those two each are federally recognized, and we know that each of those two have their own courts. They each have their own Indian courts. Now, what this argument is trying to lay out, well, first of all, it's taking a lot of this backstory, all of this backstory in here down to here. They're taking it from this brief by the United Kituah Band of Cherokee Indians in Oklahoma in support of respondent Victor Manuel Castro Huerta, and it's in State of Oklahoma v. Victor Manuel Castro Huerta. In this particular case, the State of Oklahoma filed charges against Castro Huerta for child abuse. The child in this particular case was an Indian child. Victor Manuel Castro Huerta was not. And the Supreme Court said that the state could still exercise jurisdiction over him, if I remember correctly. But anyway, the whole point of the brief that the Kituah Band of Cherokee Indians provided in this case is all based on one limited issue. And they're really looking just to prevent or to make the court aware that the decision below does not examine or decide whether the Cherokee Nation of Oklahoma possesses criminal jurisdiction over the Cherokee Reservation exclusive of the UKB, the United Kituah Band of Cherokee Indians. It merely held that the federal government has jurisdiction to prosecute the crime and the state lacks such jurisdiction. So that's what the lower court held. And what these guys are really concerned with, what the Kituah Band of Indians is really concerned with, is that the Supreme Court doesn't make some sort of a blanket statement like the Cherokee Nation of Oklahoma has jurisdiction over crimes committed against Indians on that particular reservation, because both tribes share that reservation. Now, the Kituah don't argue that the Cherokee Nation of Oklahoma lacks jurisdiction. What they say, and what they cite lower courts as deciding, is that both the Cherokee Nation, and this is from an Oklahoma court case applying McGirt that said that there's no evidence, yada, 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 but did not rule on the exclusive or shared nature of tribal jurisdiction. And then there's also a Cherokee Nation versus Bernhardt. In both of these, nobody ruled on whether or not either tribe has exclusive jurisdiction. And in the Cherokee Nation versus Bernhardt, they say that basically both tribes can share. There are other cases where more than one tribe shares jurisdiction over a single reservation, and this is one of those cases. And they also say that while on the ground the UKB exercises exclusive jurisdiction over its trust land, the trust land is basically the land that's been given to it exclusively by Congress, and the CNO exercises exclusive jurisdiction over its trust land, the question of shared jurisdiction within the remainder of the Cherokee Reservation remains open. The decision below didn't address it, and the court should refrain from addressing it until the issue is properly before the court. So that's all that this particular this particular amicus brief was addressing. So the Kitoa Band believe that, at least as it stands currently, the Cherokee Nation of Oklahoma has concurrent jurisdiction with the Kitoa Band as far as the Cherokee Reservation in Oklahoma is concerned. So that's problem number one that they're going to run into. So that all that was this. The next thing that they say is that the CNO, the Cherokee Nation, failed to take advantage of opportunities to form a government as provided by federal law. Now, here's the problem with that. The United States federal government has recognized the Cherokee Nation and has had treaties with the Cherokee Nation since at least the 1800s, if not before. So, I'm talking the early 1800s, like 1836 or something like that. I mean, it's a long, long time ago. And that to have a treaty with someone implies that they have a government. You can't have a treaty with an anarchy. You have to have a treaty with something that has a government, because who's signing that treaty on that other entity's behalf? It has to be someone authorized to sign, i.e. a government, right? So an issue that they have is that the United Kitoa Band was not recognized as being separate from the Cherokee Nation of Oklahoma. It was not recognized as a separate band of Indians until the mid-1900s, like 1945 or 46, somewhere in there. So once it was recognized under the OIWA, or is that the OIWA, the the Oklahoma Indian Welfare Act, it was organized under that, where tribes that were not previously recognized by the federal government were allowed to be recognized. And that's when the United Kitoa Band formed their government, because now they were allowed to have their own separate government. And both the CNO and UKB coexisted. Yeah, they were basically the same thing from 1906 to 1936 without a government. That's not true. There were still chiefs. During this period from 1907 to 1971, the principal chiefs of the Cherokee Nation were appointed by the President of the United States of America. That is correct. The purpose of these appointments, as provided, blah, blah, was to formalize tribal governments, yada, yada. And then what happened in 1970 is that Congress passed a bill. Hold on a second. Here we go. This was 1970. To authorize each of the 5 civilized tribes of Oklahoma to popularly select their principal officer and for other purposes. So this gave the Cherokee, right here, see Cherokee? They are now selected by their representative tribes in accordance with the procedure established by the officially recognized tribal spokesman and or governing entity, and it's subject to the approval by the Secretary of the Interior. Okay? So the tribal chiefs are, after basically 1971 on, the principal chiefs are elected. Okay? And again, we have the red herring about the OIWA. The UKB worked with the Department of the Interior to establish government. So that's awesome. And they say CNO neglected to take advantage of the OIWA. They didn't have to. They already existed. They were already a federally recognized tribe. And did not pursue federal recognition or approval by utilizing the process provided by the federal government in 25 CFR 83.4 and 83.11. Again, those are for, do I have them up? I don't have them up. Anyway, you'll just have to take my word for it. They don't have to seek federal recognition because this is the BIA.gov. This is the Bureau of Indian Affairs.gov. The Cherokee Nation right here, Cherokee Nation, is a federally recognized tribe in Oklahoma. Federally recognized tribe in Oklahoma. That's where we're at. So they already existed. They didn't need to take advantage of the OIWA. All right. Next thing. The CNO is not entitled to have tribal courts and thus has no authority in this case. Well, that's really weird because this is 25 U.S. Code 3601. Congress finds and declares that there is a government-to-government relationship between the United States and each Indian tribe. The government has trust responsibility to each tribal government that includes protection and sovereignty of the tribal government. Congress, blah, 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 has recognized self-determination, self-reliance, and inherent sovereignty. Indian tribes possess the inherent authority to establish their own form of government, including tribal justice systems. They possess that inherent authority. And you can see that again in 25 USC 3651. Tribal justice systems are an essential part. Repeatedly recognized tribal justice systems as the most appropriate forums, yada, yada. And they're sovereign entities. Indian tribes are sovereign entities. So, and it's a government-to-government relationship. So you can see lots of things, lots of patterns repeating here. That yes, the tribe is authorized to form its own courts. So the tribe authorized its own court. Here's an act. This is the act of, oh God, when was it? 1990, I believe. Yes, this was an act of 1990. This was when the Cherokee Nation established their own district court. Its purpose, its composition, and its territorial jurisdiction. Let's see. Territorial jurisdiction is somewhere in here. There you go. Jurisdiction. The territorial jurisdiction of the Cherokee Nation District Court shall extend to and include all Indian country, also known as Cherokee country, within the 14-county area of northeastern Oklahoma as defined by the treaties of 1828, 1833, and 1835, and the patent of 1838 between the United States of America and the Cherokee Nation, and at such other locations within the United States which qualify as Cherokee country. That would be if like they got some external, like a gaming hall or gambling casino or something like that, an Indian casino. That would also be part of their territorial jurisdiction. So this was passed by the Cherokee Nation, by their tribal government. We just saw that the United States recognized the sovereignty of their tribal government and found that they have the inherent authority to establish their own form of government, including tribal justice systems. And Chapter 38 is Tribal Justice Board. This is all about their judicial, their judiciary, just so you're aware. So, they ignored the strict requirements of the federal government as stated in 25 CFR, but they don't say which specific one, because 25 CFR is Code of Federal Regulations, and it has a lot of things in it. CFR. I'm just going to pick one at random. I'm just going to do that one. And then we're going to go up to Title 25, Indians. So there's all sorts of things in here. Lots and lots of different things. Apparently 1,299 or so different things that they could be alluding to. They don't state specifically, and I'm not going to go through the entire thing to figure out what they might be referring to. So there you go. They say instead the Cherokee Nation of Oklahoma undertook to write a constitution in 1975, purportedly by whom, I don't know, to be an amendment to the 1839 Constitution, apparently hoping that said action would be accepted by the federal government and give the Cherokee Nation of Oklahoma the appearance of having satisfied continuity of government required by 25 CFR 83.4b. Now, this is again 25 CFR 83.4b is about getting federal recognition. It's not about getting a court system. So that's we'll bring it up. 25 CFR 83.4b. Do we have it here? Actually, we just do it this way. 25 CFR and tribal government 83. This is 83 is procedures for federal acknowledgement of Indian tribes, and we already know that the Cherokee Nation is federally recognized, so they don't have to satisfy those elements. They already have established those elements. Now they're I guess we'll skip. They go into the 1975 Constitution and why they think that it's wrong. The federal scheme for approval by the Department of the Interior. I don't know why they really want the Cherokee Nation to have to do something with the organization, the Oklahoma Indian Welfare Act, and they didn't have to. So there you go. The 1975 Constitution. So this is the this is the 1975 Oklahoma Constitution. It was approved for referendum by the Commissioner of Indian Affairs, Morris Thompson, on September 5th, 1975. So it sounds like it has the federal government has signed off on it. It says the CNO drafted the Constitution in 1975. The BIA Commissioner Morris Thompson approved for referendum for June 26, 1976. Mr. Thompson, as a BIA Commissioner, did not have the authority to approve the Constitution, as that was the role of the Secretary of the Department of the Interior. Well, I mean, really, is that the case? This is govinfo.gov. I just found it here. So this is Title 25, 18 U.S.C. I just have it up here just because I needed another tab that I could recognize. And delegation of powers and authorities by Secretary of the Interior and Commissioner of Indian Affairs. For the purpose of facilitating and simplifying the administration of the laws governing Indian affairs, the Secretary of the Interior is authorized to delegate from time to time, to the extent and under such regulations as he deems proper, his powers and duties under said laws to the Commissioner of Indian Affairs. And the Commissioner of Indian Affairs is Morris Thompson. He was delegated by then Secretary of the Department of the Interior. So, and that's completely allowed here. It's completely allowed. So I don't know what they're going on about. This is the first time Cherokee Nation set themselves apart and called themselves the Cherokee Nation of Oklahoma. That's actually not correct, because it was initially just the Cherokee Nation of Oklahoma, and then the United Ketowa Band distinguished themselves from it. So there you go. Blah, blah, blah. Oh, it's circulated in 3 forms. Well, I don't think so. There is the official form that was approved for referendum. So I don't know what the hell they're going on about there. Then the 1999 Constitution. So again, this Constitution did not have any compliance with the provisions of these 2 provisions in 25 CFR subsection 83, which, as we have established, is federal acknowledgement of Indian tribes. And that's completely not at issue here. So it's submitted to the people and allegedly approved by referendum in 2003. In addition to the failure to comply with, it was signed by Larry Echohawk, a BIA employee, while he was later Assistant Secretary of the Department of the Interior. That was not his role nor his authority. Well, you know what? Let's go back to this little bad boy. Subject to the supervision and direction of the Secretary, the Commissioner is authorized to delegate in like manner any powers and duties so delegated to him by the Secretary. Blah, blah, blah. You get the idea. So that's a whole other bunch of hooey. It's not tainted. And then, anyway, I'm just going to make a long story short. Somebody else had already once said, this is in 2006, I think. Someone had once said that the 1999 the 1999 Constitution was invalid. And the court, in this particular case, found that the 1999 Constitution of the Cherokee became effective on July 26, 2003. It goes through all of the different things of it, and it says that yes, it is valid, and go to town on it. So the court has jurisdiction to determine the issues presented here under the Constitution of 1999, and the petitioner's motion for summary judgment is considered yada yada. No issues of material fact. These are undisputed facts. The present Cherokee Nation members were elected into office under the authority of 1975, and before the 1999 Constitution was adopted by the people, yada yada. So it became effective. It is valid. So more invalid things. All right. The District Court and the Supreme Court of the CNO were established on November 13, 1990, at a time when there was no authorization in effect for those courts. The District Court and it was not called the Supreme Court at the time. It was called the Judicial Appeals Tribunal. I think I showed you where that was created here in 1990. It was created. They're a sovereign government. We've been over that, and they have the right to do that. The CNO passed another Constitution in 1999 or 2003 that purports to be an amendment of the 1976 and a repeal of the defunct Constitution. It doesn't matter. It is still valid. CNO courts still operate under a cloud of illegitimacy, lack of judicial independence, and unrepealed congressional ban on Cherokee court system taint tribal judicial process. They have never established in this brief any sort of a congressional ban on a Cherokee court system. They're going over the shadow of the Curtis Act of 1898 expressly abolished the Cherokee court system. Yeah, that was in 1898. Congratulations. It's more than a century later. Hodel v. Muskogee Creek Nation does not apply here because this is not the Muskogee or Creek Nation. So anyway, they have a real problem here, and I don't think she's going to get too far. I don't think she's going to get too far. Anyway, I've rambled on long enough. Thank you for watching. I hope I went through all my tabs. If I didn't, I apologize. Thanks for watching. Have a great day.